Welcome to the Real and Real Estate Podcast, your go-to show for real estate success. Whether you're an agent aiming to crush it or a buyer or seller wanting the inside scoop, we're here to deliver expert advice, insider tips, and the real talk you need. Each episode, we chat with top industry pros to give you the facts, strategies, and inspiration you need to thrive in this business. Let's dive in and make big moves together. Hi, welcome back to The Real and Real Estate, where we talk to the experts and get the facts and dispel the myths. And once again, I'm fortunate enough to be here with Carey Worrell of Simple Law, Texas. And we're going to talk about community versus separate property today. So welcome, Carey. Welcome back.
Yeah, thanks. I'm so happy to be here again.
Well, I appreciate you taking the time to do this. I know that you're a very busy person, so I appreciate it.
No, I love talking to people like you and helping people out and helping people understand things that sometimes are commonly misunderstood.
Yes, or you don't have to deal with very often, so you just don't know. And yeah, yes, this is a real estate podcast, but we talk about lots of things related to real estate, and community property versus separate property is something that comes into play. Fortunately or unfortunately, if someone is getting a divorce for one thing, it's very important what's community and what's separate. So thank you for taking the time to kind of define this for us and give us some guidelines.
Yeah, absolutely.
So it's my understanding that, and I may certainly be wrong here, but you can correct me, if a person owns property before marriage, it is their property, not community property. Am I correct on that?
Yes, that is correct. But what you kind of highlighted is something that people commonly um, misunderstand. Some people think that, oh, Texas is a community property state, so when I get married, everything becomes community property. But like you
Yeah.
said, that's not really true. If you own something before you're married, that is your separate property, and it remains your separate property even after you get married, unless you convert it to community property somehow or the other. And like you mentioned at the outset too, not only is it important in a divorce situation, it's also important in an heirship situation because the
Oh,
rules for who gets your property if you were to die without a will are different for if something is separate property or something is community property. And so that is going to be important, especially in the real estate context, knowing, okay, I'm working with a client or I am a seller or a buyer. This property was inherited from somebody who owns it now. Well, it matters whether it was community property or separate property before that person passed away.
that's excellent, excellent. Let's talk about that. If someone dies without a will, and if you die without a will, shame on you because everybody needs a will. You
I
do. You own a
definitely
car,
agree
you
with
need,
that.
if you own a car, you need a will because somebody's got to know what to do with it or who gets it. But
Exactly.
let's say that they did not follow the rules, they died without a will. How does, and they have a wife and children, maybe children of their own or children from a past? I'm asking you a lot of questions, I know, but can you kind of give us an overview of what that might look like?
Sure. So that is a multi-part answer,
Yes, it
but
is.
you identified all of the things that are important to consider, right? So when somebody passes away, you want to say, okay, were they married or were they not married? Did they have children or did they not have children? But also, as you mentioned, were their children also the children of their spouse? And all three of those things matter. Once you figure out those, then you look at community property versus separate property. So when we think about community property, and I won't belabor you or your listeners with all of the very specific rules, but they can all be found
They're too, yeah,
in the Texas
too many.
Property Code or Texas Estates Code. But the reality of it is, when we think of someone's separate property, that's property that they owned either before they were married or property that they got a certain way while they were married. So, property that you inherit while you're married is still your
Okay.
separate property. Property that is a gift to you is your separate property. It's kind of assumed that all of those things are really meant for your family line, your descendants, right? Because a lot of
Okay.
times your separate property is something that you got from your ancestors, so to speak. Maybe you inherited it,
Mhm.
maybe it was a gift. And so it's presumed that most people's intention for their separate property is to leave it to their children as opposed to their spouse. So when you have separate property and you die without a will, that for the most part will go to your children. And
Okay.
so If that's not your intention, like you said, absolutely you need a will, because if you have a will, you can make it say whatever you want, right? But if you don't have
Right.
a will, the laws of the state of Texas decide, and they have decided that most separate property goes to your children, not your spouse, regardless of how long you have been married. Um, Community property will mostly go to your spouse, because it's presumed that the intention for community property is that you share it with your spouse. However, the rule changes a little bit. Well, it actually changes a lot if you have children that are not the children of your spouse. Even
Ah,
then, your community property, half of it at least, will go to your children, not your spouse,
okay,
even
that's
your
good to
community
know.
property. Yeah.
Okay.
And so it's important to know a lot of times, if you're going on a listing presentation, you're an agent, it's important to know, is this property community or separate property? Because that is what determines who's allowed to sell it, who's going to get the proceeds
Mhm.
when it is sold. And a lot of times I hear people say, oh, well, the property is just in my name or it's in both of our names. And that doesn't really matter. It doesn't really matter whose name it's in, although that might be evidence of how it was acquired. It matters when you acquired it. Was it before you were married or after you were married? How
Mhm.
you acquired it. Did you purchase it with income or did you receive it as an inheritance or as a gift? And what you've done since you acquired it. Have you kept it as it originally was, or have you somehow mutated it from separate property into community property or vice versa? So, all of those things matter. The person's name on the property doesn't actually matter as much as people think it does.
Wow, my head's spinning. Okay,
Sorry.
so as a real estate agent, how would someone clarify? Let's say you die without a will, intestate.
Mhm,
There are children from another marriage, and or even yeah, we'll just say that children from another marriage. They would get 50% of the
mhm,
community property if there's
mhm.
no will. But as a real estate agent, let's say there is no spouse, they just got the property. How do I verify who has the right to sell it? Did I ask that question correctly? Do you know what I mean?
Yeah, yeah, you did. And it's an important question. And sometimes it is very hard to know who has the right to sell it. Um, there are a couple of things you can look at. One, you can kind of look into who passed away. Was their estate probated? When did they, get this property? Sometimes the answer will be easy. Sometimes it's more complicated. And honestly, I would recommend most agents either talk to a title company, because a title company, before they are willing to close on that property, they're going to determine who
Okay,
has the
great.
ability to sell it, right? So if it's not apparent to you as the agent, get with a title company. And this is where partnering with title companies and having,
Very important.
consistent relationships with people that you
Yeah,
know and can call is very important, because they can find that information for you or help you. Other
great.
resources would be a probate attorney or a real estate attorney will know where to look and know the questions that you can ask in order to determine, hey, is the person I'm talking to actually even the seller? I don't know. I mean,
Hmm.
sometimes it's obvious that they are, but not always.
You can't be too
So
careful.
no, definitely. You don't want to get all the way to closing and then realize the person you've been talking to and working with this whole time is actually not the person who has authority to sell it.
Yeah, that's a big problem. It won't
Yeah,
be sold for sure.
absolutely. It'll definitely be delayed at the very least.
Well, there are a lot of rabbit holes we can go down here, but we're just doing an overview. So, what else do we need to know about that situation? If obviously, do you do wills for people? I'm just
We
going to
do,
ask you.
yes. Yeah, we
Okay,
do.
so if you're listening and you don't have a will, please call Carey or call someone, get a will. That makes
Yes, we're
everybody's
happy to
life
help.
easier.
Yeah.
Great, great. But what else do we need to know? If there is no will, we've talked about that. If there are not children, it's just a spouse, then how is that handled? Do you just go to court? Do you need letters from anybody? How do we handle that?
If there are no children and something's just going to a spouse, there are a lot of different processes you can use. You can use an affidavit of heirship. You may need to go to a probate court. It's really going to depend on everybody's situation. But one
Situation. Yeah.
thing, yeah, even before people die, one thing I get a lot of calls on, and a lot of these calls, these referrals come from realtors. So I know these people are asking their agents
Mhm.
first this question, and the
Right,
agent doesn't know the
right.
answer. So something that I think could help, set agents apart with knowledge they can provide to their clients, um, is someone will call and say, "Oh, I bought this house before I was married. I'm married now. I want to add my spouse's name to the deed.
Right.
And so they call and want to do that. And it's an interesting case in talking to people and finding out why they want to do that, because if you bought something before you're married, it's your separate property and it's going to
Right.
remain your separate property. If you add your spouse's name to the deed afterwards, which you absolutely can do by deeding a portion of it to them, you're essentially giving a gift to your spouse of part of your separate property.
House.
And
Hmm.
any gift to a spouse is also separate property. So when you do that, when you add somebody's name to a deed, and that's usually what people refer to. It's not really adding their name to a deed, it's executing a new deed and giving a portion of your property to them. When you give it to them as a gift, that is now seen as their separate property. So now that home or other piece of real estate is owned half by you as your separate property and half by your spouse as their separate property,
Hmm.
which a lot of times is not really what people intended when they said they just wanted to add their spouse's name to the deed. What
They
they
don't
wanted
realize
was
what
for
they're
it to,
doing.
exactly, they don't realize what they're doing. A lot of people do this themselves and they don't realize it. And, unfortunately, actually had a client recently that did this. And then the spouse passed away, and the spouse did have children from a previous relationship.
Ah,
And now that portion of the house that he gave her as a gift and is her separate property goes to her children. It doesn't come to
right.
him. And in that case, it was actually a sad case because that was land that had been in his family for generations.
Oh
Well,
no.
now it's in her family for the next generations coming down. And that was not what he intended. But he didn't talk to a realtor, a title company, a lawyer, somebody that could have pointed him in the right direction. And even if the realtor can't draft the documents, just knowing, hey, don't do that yourself. Make sure you talk to somebody before you do that because there's unintended consequences. And you can do
Yes.
that without giving, legal advice. You can just say, look, I don't know the advice for your situation, but I know that sometimes that has community and separate property ramifications. You should definitely talk to a lawyer. I think that's how,
Yes.
agents can add value without crossing the line into practicing law, which I know is very hard for very hard for a lot for agents to do, honestly.
Well, I like to refer everybody to experts, and that's one of the reasons I do the podcast. It's not my job
Yeah,
to be an attorney or a plumber or an inspector or any of that. Let's talk to
exactly.
the experts. And now, time for a short break.
Ready to jumpstart your social media strategy? I'm Katie Lance, and the Get Social Smart Academy is your go to for smarter content planning. Get weekly trainings, Canva templates, and AI tools to save time and grow your business. Go to katielance.com/academy to join us today.
So, in that particular case, you mentioned had he had a, or had they both had a will that specified he got the property, that would have solved the problem, correct?
That would have definitely solved the problem, assuming that his wife was willing to leave it to him in the will. But as
Right.
soon as he deeded it to her, I mean, she can do whatever
It's
she
her
wants.
property.
It's her property now. She's not
Yeah.
obligated to deed it back to leave it to you. And I think sometimes people want to add other people to a deed as kind of a showing of commitment or
Commitment.
affection, and they don't really think about the possible ramifications. And there are other ways you can show that commitment, but also keep yourself, legally protected. But you're not going to find out about those most likely unless you ask a lawyer or, some sort of expert, depending on what the situation is.
Yes, and it's cheaper in the long run to do that. So
Oh,
don't think about
absolutely.
yeah,
Absolutely. I
if
mean,
you
and
would have
in this
been much better
instance,
off.
there's really no way to fix what happened.
Yeah,
There's no
it
way to
is
get
what
it
it
back.
is.
Yeah. Unless of course her kids are willing to give him the property, which actually I have had happen sometimes. The kids say, "Look, I realize that wasn't the intention," and they will sign the property back over, but a lot of times they won't. Kind of depends on that
Oh,
relationship.
yeah, a lot of times they won't.
Yeah.
And if a couple, let's say, the wife owns a property and they refinance together, that makes it community property, correct?
So if you refinance, it's going to depend on what that deed looks like. So if you refinance and you put both people's name on it, likely your mortgage company is going to require a new deed. And
Okay.
so, yes, that new
At that
deed
point,
is going to convert it to community property. Potentially. It could also do what I mentioned a minute ago, make it two people's separate property. It really depends
right,
on how the deed is worded
is
because either
written.
one of those is a possibility. But you bring up a good point on the refinancing, right? A lot of people say, well, I bought this house when I was single, but it has a mortgage on it. So I really only had let's say $20,000 worth of equity when I got married, and it's maybe a $200,000 home, even though that money that you pay the mortgage down with is community property because it's income that you earned after you were married,
Right.
the house itself still remains separate property. And so when you go to sell it, that is still separate property. However, your spouse or the community estate, the community part of your property, would have a claim for reimbursement on the amount that they paid towards it. So if community funds were used to pay down a mortgage, then upon selling it, a portion of that money that was paid towards the mortgage, but just actual dollar for dollar, would be returned as community property. But if there was an increase in value, let's say that home went up from 200,000 to 400,000, that increase in value is still separate property. So
Yeah.
when you go to sell it, the increase in the value stays with the original owner, whereas the amount that was contributed towards it can be reimbursed as community property.
As repeat myself, my head is spinning. Okay, so much to know. So much to
Yeah.
know.
Well, because a
Just
lot of
call you.
people assume like, oh, I had $20,000 equity, or my spouse had $20,000 equity when he bought it before we were married. Now we're selling it after we're married. Everything over $20,000 belongs to the community estate. It's community property.
Right.
That's not true. Only the portion that you actually paid in do you get back. The increase in value still belongs to the original owner as separate property.
Oh, wow. Okay. All right. So much. Now, if someone doesn't have a deed or doesn't want to do a deed, can they do a transfer upon death? Is that what it's called? Transfer upon death?
Yeah, so a transfer on death deed is something that you would use. It's kind of like a beneficiary designation for real estate.
Okay.
So, like, if you have life insurance or 401(k) or something like that,
Right.
you usually designate a beneficiary. It goes automatically to that person when you pass away. The same is true for real estate with something called a transfer on death deed. It is like a deed. It looks kind of like a deed, but it basically says, when I pass away, I want this property to go to Jane Doe.
XYZ.
If Jane Doe is not alive, then I want it to go to these people. And that just automatically transfers the property at your death. All you need to do after that person dies is file something called an affidavit of death in the real property records. And that is sufficient to show that the property has gone to the next person with no need for a probate, no need for, an affidavit of heirship or
Yes.
anything like that.
Great. And I assume you can do those, process
Oh
those for
yeah,
people too.
absolutely. I mean, that is
Okay.
definitely the most recommended way to uh,
Make a smooth
easily
transition.
plan for a transfer of real estate upon your
Yeah.
death. It's revocable. If you sell the property, it just basically goes away. Now, it does need to be filed in the real property records before somebody dies, and it is
Okay.
specific to a piece of property. So if you sell your property by new property, you would need a new transfer on
A
death
new
deed,
one.
whereas you wouldn't normally need a new will.
Got it.
But you definitely want to still have the will, even if you also have the transfer on death deed, because there's
There's
likely
other
going to be other
things.
property, or maybe there's a mistake, or who
Yeah.
knows? It could be anything.
Yeah. Well, what else do we need to know about community and separate property that we haven't discussed yet?
I guess, one thing to think about, especially if you're working with clients that are maybe getting married, is a prenup, right? Because there are
Yes.
rules regarding what's community and what's separate property, but you can agree to change those rules. And that's
Okay.
basically what a prenup does. You can also have something called a postnup, which is executed after you're married, but that's basically where a couple says, okay, we know what the rules are, the default rules. We would like to establish our own rules,
Do it
something
our
different
way.
than the default rules, do it our way. And it's just the same as a will, right? So the will is like there are default rules for who your property goes to, but a will says I'm making my own rules. Same with a prenup. There's default rules as to where this property would go, but we're making our own rules. Um, and if somebody has a prenup, that's another good question actually for realtors to ask their clients. Do you have a prenup? That would, change the nature of this real
Right.
estate to either make it community or separate property when the default might have been something else. So couples can do that, and they can designate what happens to this property if we get divorced. What happens to this property if we die? Is this, even though this would normally be separate, we're going to call it community, or vice versa. So that's also another thing to think about is whether you want to change the rules. But honestly, knowing whether you want to change the default rules requires you knowing what the default rules are. Because a lot of
Yes.
times I have people call and they say, "Oh, I want a prenup." Okay, great. What do you want your prenup to say? Well, I want my prenup to say that everything that I have before I'm married stays mine. I'm like, well, that's already the rule. You don't need a prenup for that. Um, but you can still right, designate, look, we're acknowledging that this specific piece of property is community property or is separate property. Because even if the default rule is something you're happy with, there can always be people later that say, oh no, wait a minute, that's actually community property or that's separate property. If you've already written down a list of what you've agreed
Yeah,
is the separate property, it's kind of hard to say that later.
absolutely. Yeah, it's better to be prepared.
Yep.
And I
there's
hadn't even
there's
thought about a
never
prenup.
Yeah, there's never such thing as putting too many things in writing. Well, maybe there is, but generally not.
Well, you know what? It makes it so much, for instance, in case of death, it makes it so much easier on the people you leave behind. And I think that's something people need to think about. Yes, you don't want to think about dying, and you're sure that nobody's going to argue or fight, but why give them that temptation? Keep the
Right.
family together, eliminate the fighting, hopefully, let them know
Yeah.
what it is you want. So I think it's better for the people you leave behind.
Absolutely. I mean, there are so many families, honestly, that are torn apart after somebody dies because of something that was
Fight.
ambiguous or not clear,
Yeah.
and it is so unnecessary. And it's sad, and that's never what anyone would have wanted. And it's really interesting. Some of the people who are most adamant about getting a will are people who have gone through the process of having a family member die without a will. Because once you've gone through
Yeah.
that and you see the hassle, the expense, the heartache of it, you never want that for anybody else in the future, even if you're not going to be around to see it. Um,
Yeah.
because it really can split families apart. It's really sad.
Yeah. And there's enough work for the people left behind to do without having to deal with the extra stress of figuring out what everybody gets and
Right.
what you wanted and what you didn't want.
Exactly. Exactly. It's always easier if it's in writing.
Yeah. Well, Carrie, we're running a little late on time, a little short on time. Any last words of wisdom or advice other than giving you a
Um,
call? But
I mean, my advice is really always the same. Just make sure you talk to an expert in whatever field, but specifically the legal field today,
yes.
before you try and DIY something. There are lawyers out there. I mean, I'm one of them, but there are many other excellent lawyers that you can just have a consultation with for a pretty low cost. And the answer at the end of it may be you don't need to do anything. You're fine how you
Right.
are. Um, but it's always worth knowing. It always saves money in the long run to get an expert to chime in on any of these things.
Money and stress, yes, because the law,
Yes.
I mean, unless you're an attorney yourself, and even then, you may not be in the area of expertise that you need, so
Yeah,
always
absolutely. And
consult.
I mean, and people call me all the time. I want to sell my house, for sale by owner. Will you look at the contract? I'm like, well, I will, but that's all I'm going to do. And I refer people to realtors all the time for the same reason. Like, you need an
Yeah,
expert. I'm not an expert in marketing property, pricing property, you know, all of those things, organizing the sale and things like that realtors do. And a lot of people, just try and cut corners thinking it's going to save money, but it almost never does.
it often ends up costing you more money because you
Absolutely.
screwed up something, to be
Absolutely.
honest.
Absolutely.
Well, Carrie, if people want to reach you for a consultation, advice, whatever, to write a will, hopefully,
Yeah.
that everyone out there is going to get a will, how would they reach you? What's the best way to reach you?
Best way to reach me is through my website. It's simplelawtx.com. We have a link right on there. You can either contact us or you can just make an appointment directly on our website. But also follow me on Instagram. I try and put a lot of helpful content out
Oh,
there.
great.
I offer some free webinars specifically for realtors that are usually announced on Instagram.
Fantastic. Okay. Follow Carrie on Instagram then. And is it just Simple Law
Simple
Texas
Law
or?
TX. Yep, Simple
Okay.
Law TX.
Okay. Well, thank you so much, Carrie. I really appreciate you being on here again.
All
This was
right.
we could talk for a long time on all the specifics here, but this gives us a great idea of where we need to go and what we need to do and what we need to think about it. So I
Yeah,
appreciate it.
absolutely. Thanks for having me.
Thank you for tuning in to the Real and Real Estate Podcast. I hope today's insights have inspired and empowered you. Don't forget to subscribe, leave us a review, and share the podcast with anyone who might benefit. Have questions or a topic you'd like us to explore? We'd love to hear from you. Until next time, stay informed, stay inspired, and keep moving towards success.